After the Civil War, the Congress of the United States, still missing representatives and senators from the South, began a process of defining human freedom. It was a slow process and much compromised. After abolition in the 13th Amendment, Congress realized that much of its initial civil rights legislation, to put it mildly, was of questionable constitutionality. And so they set about passing amendments designed to provide after-the-fact constitutional justification of what they'd already enacted. This led to the 14th Amendment, which provided a link that Mr. Lincoln tried to say existed between the Declaration of Independence and the Constitution. In truth, despite his arguments, there wasn't much of a link prior to the 14th Amendment. It was the 14th Amendment that allowed us to begin to think about that. But the Civil War and this process let loose an idealism that, at least initially, had some pretty quick effects. Congress did what hardly anyone prior to the Civil War foresaw, and that is provide for voting rights for African Americans. You've probably seen the recent movie Lincoln, where that's one of the hypothetical horribles predicted if there is abolition of slavery. Likewise, there were similar protestations regarding the 14th Amendment. But unfortunately, that isn't all the story. Tragically, the United States Supreme Court, for over a century, betrayed and undermined the 14th and 15th Amendments with a score of decisions that designed to allow the South to preserve white supremacy for generations. I can't talk about all of them. I don't want to, but a few need to be explained in order to understand the importance of a 1965 case called Katzenbach v. Morgan. United States versus Reese, in the centennial year of America, 1876, allowed the white South to circumvent the right to vote on any other ground other than race. And so you began to see poll taxes, literacy tests, understanding clauses, good character tests, and other devices that just happened to result in mass disenfranchisement of black citizens. Still, black voting increased. The white South pushed back with tactics of terrorism and repression. The poll tax proved to be ineffective as African Americans scraped their savings and their earnings to pay the poll tax. So the South brought in something called the 8-box law, and this was designed to frustrate the illiterate and semi-literate African American voter who needed party help to properly cast a ballot. Could no longer fill it out and deposit it in one box. You had to separate it out and deposit it in 8 boxes. You may not know that the secret ballot was imported to prevent political assistance by the Republican Party to black voters. Despite all these efforts, percentages of black voting remained high through the 1880 presidential election. Faced with continuing high black participation, the South pushed back again. In the era between 1880 and 1900, you saw a series of Southern conventions, all designed to utterly exclude black people from citizenship rights. Mississippi led the way. It adopted a requirement that always gets a laugh from my students. Voters had to read and interpret the Constitution of the United States accurately to the satisfaction of a white examiner. I just tell them that, imagine not being able to vote if you failed your constitutional law exam. That's what it was. Statistics were generated to show that, just surprisingly, illiterate and semi-literate whites passed almost 100%, and blacks failed 100%. Now, when opponents of these measures accused their advocates of discrimination, there was an unusual burst of candor. A delegate to the Virginia State Constitutional Convention proclaimed, quote, "Discrimination? Why, that's what we propose. It's exactly what this convention is for." Chairman of the Mississippi State Convention of 1890 put the matter simply, "Let's tell the truth. If it bursts the bottom out of the universe, we came here to exclude the Negro." Here's their version of political reform. Quote, "It's no secret that there's not been a full vote and a fair count in Mississippi since 1875, and we've been preserving the ascendancy of the white people by revolutionary methods. In plain words, we have been stuffing the ballot boxes, committing perjury, and carrying the elections by fraud and violence until the whole machinery for the electioneering was about to rot down." Well, the Supreme Court took note of this and admitted that much of what was happening was, quote, "a fraud on the Constitution of the United States," but they couldn't do anything about it. Segregation statutes succeeded this change in politics. It did not precede this change in politics. Oklahoma followed Louisiana's lead and adopted, upon admission of the state, a grandfather clause, which you may know is simply saying literacy tests have to be administered to everybody except the grandsons of those who'd voted in 1860. It was actually a serious attempt to deny that this was a tactic of race discrimination. The first dean of the law school at the University of Oklahoma denounced the grandfather clause in an article in the Harvard Law Review. Purpose of the measure, he said, in very clear terms, was designed to exclude black voters. He argued and predicted that if the case came before the Supreme Court, it would be struck down. And 3 years later, his prophecy came true. The first recorded moment when an academic at the University of Oklahoma made an accurate prediction about the U.S. Supreme Court. I know I've made many inaccurate predictions myself. I admire that achievement greatly. The case is Gwynn versus the United States. Now, Dean Winnett's commentary offers background to the achievement of the Warren Court in the 1960s. You have to begin with an understanding that technically there is no national electorate. Suffrage comes from the states. We have 51 separate state electorates. There was an echo of this in Bush v. Gore. The individual citizen has no individual right under the Constitution to vote for electors of President of the United States unless and until the state legislature gives them that right. And that's still the state of affairs today. Remedies for all of this, without changing the basic beginning points, was a long time coming. The Warren Court decided the reapportionment cases. There was a judicial abolition of the poll tax, eventually a constitutional amendment against it, and most important, the Voting Rights Act of 1965, which was a congressional political remedy designed to expand voting rights for all Americans. The most important case challenging the constitutionality of the Voting Rights Act came when states complained that this interfered with their state power to decide who votes. The case is Katzenbach versus Morgan. And the question was, just like Williams versus Mississippi, the literacy test. Could states adopt literacy tests? The most recent precedent, even by the Warren Court, was a Lassiter case of 1959. Literacy tests are okay. What Congress did is it suspended literacy tests in a number of ways. In the case that's pertinent here, they said no literacy tests would be required for individuals who had completed the 6th grade in Puerto Rico. That was challenged by New York, not the South. The question was whether Congress had power to adopt a broad remedy to abolish or suspend literacy tests in order to secure equal protection, both the 14th Amendment and 15th Amendment issue. In another one of the historic opinions by Justice William Brennan, the Supreme Court deferred to the power of Congress. They avoided many of the questions about whether Congress was showing disrespect for the power of the court to interpret the Constitution under Marbury versus Madison. and adopted a principle that still exists today. You don't have to have the Supreme Court give you prior approval before you can adopt a remedy. Congress can adopt a more sweeping remedy if it has a rational basis, a reasonable basis for concluding that there is unequal protection. And in this case, there was. Every politician in Congress who has very great political expertise knows that voting gives people the chance to gain politicians' attention. Voting is a right to make sure that the Puerto Rican community in New York got garbage service, police enforcement, and other municipal services. The means were giving Puerto Ricans the vote. The ends were equal protection in municipal administration. And every politician knew that that was rational. Even Mitt Romney understood that. Remember the comment about gifts? They give gifts to get votes? Well, it's part of basic democratic theory. Equal protection is the right to vote and make sure you get services from the people. Well, so said the Supreme Court in this famous case, upholding the Voting Rights Act from a states' rights theory. The court reached back to McCulloch versus Maryland, the 1819 bank case decided by John Marshall, and said when it comes to these questions, Section 5 of the 14th Amendment, which gives Congress the power to carry out the amendment, and Section 2 of the 15th Amendment, which says the same thing about the right to vote for blacks, is just a question of means and ends. As long as there is a basis, a rational, reasonable basis, for saying the means further the ends, judicial inquiry is at an end. Justice Harlan wrote a dissenting opinion. Now, I usually disagreed with Justice Harlan, but I loved him because he was my most effective constitutional law professor when I was going to law school. I could turn to a Harlan opinion and know what was going on in the case. He wrote clearly, he defined issues precisely, he told me what the real lines of battle were. And what he basically said is this was an enormous change in the separation of powers and in federalism. And whatever you think about the wisdom of his ultimate vote, he was stating the truth of the significance of Katzenbach versus Morgan. It is proof once again that many of our rights and many of our liberties come from political action. You can't just rely on the Supreme Court. Later this term, the Supreme Court will decide the Shelby County case, and that's going to raise the question about whether certain provisions of the Voting Rights Act are to be overturned, even though they've been renewed by Congress as late as 2006. That decision will tell us whether Katzenbach versus Morgan still survives. Thank you.
Freedom 101 is made possible by generous support from the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.